I would ask that everybody please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I'd like to welcome everyone here. Those of you in the audience, please make sure that you scan the QR code or sign in. Make sure we acknowledge you were here. And with that, we'll move to our admonishment of the state with the state ethics law. Mr. Gray, if you would.
Thank you, Mr. Chairman. And in accordance with the State Ethics Act, it is the duty of every board member to avoid both conflicts of interest or appearance of conflict. If any board member has any known conflict of interest or appearance of conflict with regard to any matter coming before this board today, please so state the conflict or appearance of conflict and refrain from any deliberation and vote in that particular matter.
Thank you, sir. We're going to change the agenda that was sent out. We have two board members who are going to have to leave early. So what we are going to do now is I'm going to turn the program over to Mr. Gray. Mr. Gray will handle the election of our officers and our chair, vice chair, and the standing committee chairs. That is a requirement under state law that our first meeting after June 30th that we conduct the election. So Mr. Gray, I will turn that over to you, please, sir.
Thank you, Mr. Johnson. This board elects all of its committee chairs. So in addition to the chair and vice chair, which are set forth in the statute, you elect all of your committee chairs. The board does have bylaws. There's a very short section on the election, but according to your bylaws, as well as the tradition of this board, if there is only a single nomination for a particular office, that it is appropriate to have a motion to close the nominations and that person be elected by acclamation. It goes much faster that way, and it is very rare that there is more than one nomination for each office of the board. But you elect your board chair, your vice chair, your grievance committee chair, your screening committee chair, your chair of training and education, a legislative chair, which doesn't do a lot, but you still elect them unless we decide to have a bill, a finance chair, an emerging technologies chair, and unlike a lot of boards, you elect your ethics liaison commission. So those are the positions, chair and vice chair, and then chair of each of your committees, and then the ethics liaison. And so I will take them in that order, beginning with the office of chair. So at this time, I would open the floor for nominations for chair of the Protected Services Board.
I nominate Steve Johnson.
A motion to nominate Mr. Johnson. Is there a second?
Second.
Numerous seconds. Ms. Graham, just pick one. Okay.
Pay your money.
Are there any other nominations?
I move we close the nominations.
All right. And then we appropriate to have a motion to elect Mr. Johnson by acclamation. Do you make such a motion?
I make such a motion.
All right. And do we have a second?
Second.
Motion and second. All in favor, say aye.
Aye.
All opposed? Congratulations, Mr. Johnson.
Thank you, sir.
Strong.
At this time, I open the floor for nominations.
I nominate Andy Renfrow for vice chair.
I'll second that.
Yeah.
We're just, I'm going to let Ms. Duncan. Mr. McRae and I can he's putting words in all of our mouths, aren't you, Mr. McRae?
Well, I'm on my way out.
I know, no, you're in a hurry. You've got a meeting to go to. All right. Let's see if we can straighten this up. We have a nomination on the floor for Mr. Renfrow as vice chair. Is there a second? Second. Motion and second by Mr. Scroll. Are there any other nominations?
Move we close nominations and by acclamation.
We have a motion that Mr. Renfrow be elected by acclamation. Is there a second?
Second.
All in favor say aye.
Aye.
All opposed, like sign. Okay. At this time, I'll open up the floor for nominations for chair of the grievance committee.
I nominate Judge Ron Burris.
Okay. Is there a second?
Second.
Second by Mr. Troll. Are there any other nominations? All right.
Motion to elect by acclamation.
There you go. You first that they be closed and then by acclamation, but, Ms. Graham will fix that. All right. We have a second.
Second.
All right. All in favor of Judge Ron Burris being elected as chair of the grievance committee, please signify by saying aye.
Aye.
Opposed, like sign. All right. And at this time, I would open the floor for nominations for chair of the screening committee.
I
I
nominate,
nominate Stacy Buck.
Okay.
same one.
Would you like to second that, Mr.?
That's
Gray?
right.
All right. I have a motion and second. Are there any other nominations? There being none. Mr. McRae, this can be your job if you would do it.
Okay, I move that we close nominations and elect Mr. Buff by acclamation.
Awesome. Now that's second. Second by Mr. Johnson. All in favor, say aye.
Aye.
All opposed, like sign. All right, this time open up the floor for, nominations for chair of the Training and Education Committee.
I'm gonna nominate Bill McRae.
All righty,
Was that to be used in T&E?
T&E. Yes, sir, T&E.
All right.
Okay, is
Sorry.
there a second?
Second.
Second, numerous seconds, Ms. Graham. Are there any other nominations?
I move to close and elect him by acclamation.
All right, Mr. McRae, is there a second?
Second, right?
All in favor, say aye.
Aye.
All opposed, like sign.
Who was that second?
Mr. Miller. Like Mr. Bullard, I'm trying to keep up note-wise. This time I'd open the floor for nominations for chair of the Legislative Committee, which is law and rules.
That's laws and rules.
He's not following the agenda. Why would we follow the?
Oh, I'm
agenda?
following your email. I'm sorry. I'm following
No,
your
it's
email.
fine. You
Why would
keep-
it-
you-
No,
it
I'm
is.
sorry. I'm sorry. I'm
Laws and
following.
rules, right? Yeah.
I'm sorry. I'm following your email, Mr. Sherwin. My mistake.
I'll make a motion to elect Steve for Mr. Johnson for laws and rules.
Okay, and I will not follow Paul's email anymore. How dare I? Okay, Mr. Johnson has been nominated for Chair of Law and Rules.
We need a second.
I second.
Just getting ready to open up the floor. If I have a second.
Second.
Second, all right, got a second by Ms. Hatcher. Move that nominations be closed, Mr. McRae.
Move that nominations be closed and Mr. Johnson be elected by acclamation.
Thank you. Have a second.
Second.
All in favor of electing Mr. Johnson as Chair of Law and Rules, please signify by saying aye.
Aye.
All opposed, like sign. Now can I move to the legislative chair? You want finance next?
What are you talking about?
Finance.
Yes, finance.
There's not a legislation.
Not a legislative.
That's Paul, I'm going by Paul's email.
We don't have a legislative.
We still do on our,
Bylaws.
Going by Paul's
No.
email.
Form for
Okay.
reimbursement.
We will not
Do
do it.
legislative.
What's next on your agenda? What do you want?
Finance.
Finance and then emerging technologies.
Yep. And then
Okay,
ethics.
we'll do them in that order. This time we'll open the floor for nominations for the chair of the finance committee.
I'll nominate Bill McRae.
Second.
If you think I'm gonna close and acclimate myself, you're nuts.
No, sir, I wouldn't do that to you. I didn't do it to you earlier. Right. Wait, let's ask first, are there any other nominations? Mr. McRae's held this position for like 20 years.
Okay.
There being none,
I move to close by acclamation.
and vote by acclamation. All in favor, say aye.
Aye.
All opposed, like sign. Okay, who's the second? There were a couple off seconds. All right. Now, emerging technologies.
Do we have that?
This time we'd open the floor for nominations for the chair of the Emerging Technologies Committee.
I'll nominate Suzanne Creech.
I'll second that.
Is there a second by Mr. Buff? All right. Are there any other nominations?
I nominate Candace Radcliffe.
Pardon?
Candace Radcliffe.
presume you don't want the position. All right, that is fine. We have a second.
Seriously.
Oh,
All right.
I don't know if we're winning or losing on this one.
Dies for lack of second, Ms. Creech. Okay, well, it looks like it's yours whether you like it or not.
move that we
There being
close
no
the
other nominations, thank you, Mr. McRae, Mr. McRae's moved that nominations be closed and she be elected by acclamation. All in favor of Ms. Creech? Please say aye.
Aye.
All opposed, like sign. And
Who seconded?
who seconded? Mr. Buff.
Close it.
Oh, I don't know, second closing. Richard.
Okay. Now,
Ethics liaison.
ethics liaison for nominations for serving as the ethics liaison for the board.
I nominate Deidre Hatchell.
I'll second that.
Rolling on, so.
Second by Mr. Buff. Okay, motion and second. Are there any other nominations? There being none.
Move the nominations be closed and elected by acclamation.
All right.
She's like,
And do we have a second?
second.
Second. By either Mr. Miller or Mr. Renfrow. Pick one. All in favor, say aye.
Aye.
All opposed, like sign. Okay, I'm gonna go down the list. First of all, congratulations to everybody and make sure that Mr. Bullard and I have everything correct. Johnson as chair, congratulations to you. Mr. Renfrow as vice chair, congratulations. Ron Burris as chair of grievance committee, and I think he's online. Screening committee, Mr. Stacy Buff. Training and education, Mr. McRae. Law and rules, Mr. Johnson. Finance committee, Mr. McRae. Emerging technologies, Ms. Creech. Smile. And ethics liaison, Ms. Hack. Congratulations to everyone.
Thank you, everyone. I appreciate it. It's certainly an honor and a privilege to serve. One quick item of business, if everybody, rather than sending out something, if everyone is satisfied with the committee assignments they currently have, I'll leave it alone. If you want to change, then send me an email, let me know what you're interested in, and we'll see what we can do. All right, next on the agenda is the approval of the May 2026 board meeting minutes. Everyone should have received those.
Move that we accept the board minutes as published.
I have a
one
motion
correction.
to accept, what,
One correction.
okay?
On the board minutes, it has,
Stacy Buck.
it has me down as being here, and then it has me down as being absent. I was absent, so if you can just strike through that I was not here.
Okay.
He's here in spirit, though.
That's the only correction. I couldn't be in two places at one time. I tried.
All right, with that correction, I have a motion to accept. Do I have a second? Second. And a second. Any, comments? Discussion? All in favor indicate by saying aye.
Aye.
Those opposed, like. This time, Mr. Gray, we have three finalized decisions, I understand.
We do. We actually only have two. One
Okay.
of them has been deferred to the board's September meeting. So we have for today, Mr. Joseph M. LaSorsa and Mr. George Porter. And I know Mr. Porter's here.
Okay.
I do not see Mr. LaSorsa. Mr. Porter, you want to come on up? Oh, okay. Is Mr. LaSorsa here? Joseph LaSorsa? I don't see him. Let's do that while we're waiting.
Do that.
Porter, if we could,
Okay.
Mr. Johnson. I have the copy of the official record. If anyone wants a copy of it for any reason, I'll just leave it right here. If there's anything you need to refer to it, I'll leave that right there. This time I recuse myself as counsel to the board to present this proposal for decision. Refer you, this was sent to you and attached to my attorney's report. This contested case was heard by Administrative Law Judge William W. Beasley on March 24, 2026, the Office of Administrative Hearings. Mr. LaSorsa represented himself, and I appeared on behalf of the board. Question was whether petitioner had violated 14B NCAC 16.1205A by failing to timely submit a course attendee roster, and if so, what penalty is appropriate. The administrative law judge lists the applicable statutes and administrative codes, as well as the various exhibits by number, which are referred to later in his proposal. Mr. LaSorsa appeared on behalf of himself and also testified, and Mr. Sherwin testified as director of the board. Under the findings of facts, the administrative law judge recognizes the authority of this board to regulate the private protective services industry and states that the board has the authority to approve continuing education courses, instructors, establish criteria, and curriculum for continuing education, and that you have approximately 300 approved continuing education courses. That the petitioner, Mr. Joseph M. LaSorsa, is the owner of LaSorsa and Associates and a licensee of respondent pursuant to 74C of the North Carolina General Statutes. That Mr. LaSorsa, and he does refer to him as JM because his father is also a Joseph. And so I will just refer to him as JM as he does. Mr. J.M. LaSorsa is an approved continuing education instructor for the board and has been approved to teach continuing education courses since 2011 and is subject to the board's law and administrative rules. J.M. LaSorsa was assigned instructor number 86-CEP by respondent board. Joseph A. LaSorsa, after J.A. LaSorsa, is the father of petitioner Joseph M. LaSorsa and is also licensed by respondent, although the record does not establish the category for which he is licensed. His license expired on May 31, 2025. On or about April 4, 2025, LaSorsa and Associates offered an instructional course at which both J.M. and J.A. LaSorsa provided instructions. Continuing education credit is given to instructors at board-approved continuing education courses pursuant to 14B NCA 16.1203D. On or about April 30th, 2025, J.A. LaSorsa filed a course attendance certification with respondent claiming the April 4, 2025 course was the board's pre-approved technical surveillance countermeasures PPSB-19-004. The certificate identified the instructor as Joseph LaSorsa, 86-CEP. The certificate was electronically signed by J.M. LaSorsa. There has been no averment or suggestion that the signature was fraudulent or unauthorized. Respondent occasionally verifies course attendance certifications by comparing the certificate with the roster of attendees required pursuant to Rule .1205. When respondent tried to verify J.A. LaSorsa's attendance at the April 4, 2025 course, respondent found that there was no roster of attendance on file for that course or any course past 2 years taught by petitioner. The absence of filing a course attendee roster was brought to petitioner's notice in an email dated June 9, 2025. Petitioner submitted an internal roster to the respondent via board investigator Martinez, and that should be Martinez. However, it was rejected by the board staff as it was not on the form the board requires. The internal roster did not include J.A. LaSorsa's name as an attendant. Accordingly, to the extent a roster was submitted, it was overdue. Respondents' Grievance Committee conducted an informal review and recommended finding a violation of 14B NCAC 16.1205A, the issuance of a letter of reprimand, and the assessment of a $1,000 civil penalty, petitioner's failure to submit the required continuing education roster. This recommendation was adopted by respondent on January 15, 2026, and petitioner was notified by letter dated January 16, 2026. Petitioner J.M. LaSorsa requested a hearing before respondent by email on January 21, 2026. Respondent initiated this matter by filing a notice of hearing on January 30th, 2026, or a letter of reprimand and assessment of civil penalty. Disciplinary action was for the following reasons: failure to submit continuing education roster. Paul Sherwin is the director of the respondent. At hearing, Mr. Sherwin testified that the filing of course rosters is required only if the course is marked as being eligible for continuing education with the respondent. The undersigned found this testimony credible, notwithstanding respondent's severe any course the petitioner might conduct requires filing the roster. Conclusion of law, judge recognizes the jurisdiction of the Office of Administrative Hearings to hear this matter, that the parties were correctly designated, and that all parties received notice of the hearing. And then there's provision in there to the extent that findings of facts contain conclusions of law and vice versa, they should be considered without regard to the labels. He also recognized that the respondent has the authority to approve continuing education courses, approve instructors, and establish criteria and curriculum. Pursuant to NCGS section 74C-5, respondent has the authority to adopt rules to carry out the provisions of chapter 74C of the general statutes, including the authority to require the submission of college reports and information by licensees under this chapter. The board adopted 14B NCAC 16.1205, which requires inter alia that course instructors of continuing education courses for credit maintain a roster of course attendees and that the roster be delivered to the board within 2 weeks of the completion date of the course. That is 14B NCAC 16.1205A. Continuing education refers to any educational activity approved by the board under 14B NCAC 16.0201. Contrary to respondent's position that petitioner must file a roster of students for every course taught, respondent does not have the authority to regulate courses which are not offered continuing education, notwithstanding the similarity to a course approved by the respondent. Rule 1.1205 only applies to courses approved by the board pursuant to 14B NCAC 16.1203, which qualifying continuing education credit would be received. Here, the petitioner conducted a course which both he and J.A. La Sorsa considered eligible for continuing education credit, as evidenced by their signatures on the course attendance certification. Accordingly, the petitioner was required to provide the board with a roster of students within 2 weeks of completion of the course, pursuant to 14B NCAC 16.1205. Petitioner failed to file the roster of students within the prescribed time. Respondent may, after compliance with 150B of the general statute, suspend or revoke a license or permit for violating any rule adopted by NC General Statute 74C-12A3, 14B NCAC 16.0106. Additionally, the board is authorized to issue a written reprimand to any holder of a license, training permit, registration, identification card, or firearms trainer certificate upon the determination that 1, the holder violated the provision of NC General Statute Chapter 74C or the applicable rules. 2, the violation did not result in physical injury to any person or property loss. And 3, the holder has expressed an intention to correct or has already corrected the improper activity pursuant to 14B NCAC 16.0106. Here, petitioner violated 14B NCAC 16.1205. The violation did not result in physical injury or property loss. Petitioner submitted a roster to correct his failure to timely supply one. Thus, a reprimand is appropriate as recommended by the probable cause substitute. The board possesses statutory authority in lieu of revoking or suspending a license or permit pursuant to NC General Statute 74C-12 to assess a civil penalty not to exceed $2,000 per violation against any business person or business entity found to have violated any provision of Chapter 74C or any rule promulgated by the board thereunder. In determining the appropriate amount, the board
is required to consider the degree and extent of harm caused by the violation. North Carolina General Statute, Section 74TC-17C. Here, there is no evidence that the board considered petitioner's failure to file a roster of course attendees as a license revoking or suspending offense. Accordingly, the board cannot issue a fine, as this fine is not in lieu of the revocation or suspension of petitioner's license. In any event, in determining the appropriate civil penalty amount, the board must consider the degree and extent of harm caused by the violation pursuant to NC General Statute 74C-17C. Assuming arguendo that the petitioner's action was a license revoking or a suspending offense and a fine was appropriate, a $200 fine would align more closely with the severity and scope of the offense. Record reflects only one violation. Moreover, only one individual sought continuing education credit as a result of the course, and the credit could have been denied administratively on discovery has been filed. Final decision, or proposed decision actually, is the undersigned proposes that respondent affirm its letter of reprimand against petitioner Joseph N. LaSorsa for violation of 14 BNCAC 16.0205A and not assess a civil penalty because the board did not treat petitioner's failure to suspend the court process as a license revoking or license suspending offense, and the civil penalty authority under NC General Statute 74C-17C applies only in lieu of an action. In the alternative, the board determines that a civil penalty is authorized. A fine of $200 would be proportionate to the degree and extent of harm caused by the single violation. So if you'd like me to sum that up, I will.
I'm ready to make a motion.
Let me sum that up real quick. This case came before grievance January the 14th. The findings of the grievance committee were to issue a letter of reprimand and assess a civil penalty of $1,000. That was what grievance came up with. Now the judge has offered the same letter of reprimand and feels like that $200 would be adequate. Is that?
But then
That's
says,
pretty much it.
but then says that, says we shouldn't issue a civil penalty, but says we don't have the authority to issue a civil penalty, but
Well,
then
fine.
says,
We can
but it
issue a
says
civil
if you do, but if you do, give it $200.
Yep.
I'll make a motion to,
And just let me pause here, just the grievance committee should not be voting.
Right.
Will not be voting on this matter. Yep.
so I will make a motion to uphold what the grievance committee said and not go with the administrative law judge.
All right, the ruling of the grievance committee was issue a letter of reprimand and a civil penalty of $1,000. So I have a motion on the floor. Do I have a second?
Second.
Do I have discussion?
Just a quick question, Paul, if for whatever reason, $1,000 is not paid, what's the next step?
Comes back to grievance.
Back to grievance. And then the grievance committee can decide whether to sanction the license.
Thank you.
Again, just remind the grievance committee in the vote to not vote on this.
Yeah, the members of the grievance committee who were here in January, or have to be recused, which I'm one of them.
That's
So any
Mr. Johnson.
Renfrow, I don't know.
Scroll.
I don't think Judge Burris is not online.
Johnson, Renfrow, Schroll, and Ms. Creech.
All right, any discussion? I have a motion. Did I have a second? I think,
Yeah.
Second.
Deborah seconded.
discussion. All in favor of the motion on the floor indicate by saying aye. Those opposed? Motion carries. Great. Thank you, sir.
I don't want to step away.
Switch files.
Members of the screen committee can't hear this one. Or can't.
Again, generally, I'll leave the official record here for anyone that needs to refer anything from the record. Just leave it right here on the corner.
I'm recusing myself.
Oh, are you? Okay. Yep. Well, all of screening has to be. I'm sorry. I said all of screening has to be anyhow.
Yes.
When was this held?
All screening.
Is this in March?
Yes.
You were not here, correct?
They say don't scream and ask. If you were at that meeting.
I've been at all of them. Either one you like.
Yeah, you've been all of them.
I'm not picky.
Make sure you come back.
No, I hope not. That took forever to read. That's a new administrative law judge, and we got the full load.
Mr. Porter,
The Cliff Note version.
Mr. Porter. Yes, sir. You received a copy of, the
Proposal.
findings of the administrative law judge?
Yes, sir.
Okay, thank you.
Yes,
Grey,
he
are you?
He and I have talked since then. Sitting to my left, many of y'all probably know Mr. George Thomas Porter. His matter was heard on May 26, 2026 by Administrative Law Judge Michael Byrne. The petitioner appeared pro se. I represented the board in this matter. The issue was whether the petitioner should be denied a security guard and patrol business license based on petitioner's lack of verifiable experience. Administrative Law Judge cites the applicable statutes and rules to this matter. Under the findings of facts, the Administrative Law Judge recognizes the authority of this board to regulate the private protective services profession. Petitioner applied to the respondent board for a security guard and patrol business license. He was denied the license due to a lack of verifiable experience. And then Mr. Porter requested a hearing on the denial of his license. Notice of hearing was sent, and this matter was heard May 26, 2026, with the petitioner appearing at the hearing. Mr. Sherwin, as director of respondent, testified to receipt of petitioner's application for security guard and patrol business license on December 1, 2025. Petitioner holds a private investigator license and a close personal protection license issued by the board. To be issued a security guard and patrol business license, an applicant must have 3 years of, which equates to 3,000 hours of supervisory experience in specified areas of security or law enforcement. Andrew Martin, poor Mr. Martino, nobody seems to know his name, but Investigator Martino, he has him as Andrew Martin, performed petitioner's background investigation, which includes evaluating an applicant's experience. Petitioner has 15 years experience with the Raleigh Police Department, 14 of those as a sworn patrol officer. While petitioner had a good record of service, he never worked in a supervisory capacity. Petitioner attempted to use his time as the team leader and performing as volunteer security at his church and submitted an affidavit from the church manager attesting to his volunteer hours. Respondent does not count volunteer hours since the administrative rule 14B NCAC 16.0301A2 states employed in quotation marks. This question has been previously addressed by the Office of Administrative Hearings in Kenneth Farmer versus NC Private Protective Services Board 23 DOJ 03153, and respondent's interpretation of its rule was upheld. Specifically, Administrative Law Judge Melissa Owens Blaster found a church is not one of the categories where security guard and patrol experience is recognized in Rule .0301A. Further, a person cannot obtain experience as an employee if they are a volunteer, in that an employee must be paid a wage or salary. Plummer is not dispositive or binding on the tribunal. Also, the tribunal does not defer to an administrative agency's statutory or rule interpretations, but will consider and respect the agency's reasoning and cites a particular case. Petitioner testified on his own behalf and stated that he had also been a field training officer or FTO while at Raleigh PD. On rebuttal, Director Sherwin, himself a former law enforcement officer, testified that an FTO is not a supervisor, only a trainer for practical experience. Further, he explained that supervisor is not defined in respondent's administrative rules because staff uses the common accepted definition of the word. Even if an FTO were a supervisor, those hours would not be sufficient to meet the rule requirements of 3,000 hours. Under conclusions of law, the Administrative law judge concludes that parties are properly before the Office of Administrative Hearings, that under 74C-2A, that you must have a license to engage in the security guard and patrol business, that under 14B NCAC 16.0201, 3 years of experience equates to 3,000 hours. Pursuant to 14B NCAC 16.0301A2, an applicant for a security guard and patrol business license must establish 3 hours of experience as a manager, supervisor, or administrator in security with a federal, state, county, or municipal law enforcement agency performing guard and patrol functions. Respondent presented evidence the petitioner did not have the requisite 3 years or 3,000 hours of supervisory experience. Petitioner presented insufficient evidence to prove he has the requisite 3 years or 3,000 hours of supervisory experience. Tribunal does not find respondent's interpretation of its supervisory experience rule to be in violation of the Administrative Procedures Act. Tribunal proposes the respondent revisit its experience requirements, including its definition of terms to provide greater clarity for applicants. Based on the foregoing, the tribunal makes the following. Petitioner proposes that petitioner be denied a security guard and patrol business license. And that just a reminder for the screening committee members, except Ms. Duncan, who was not present. I believe they've all physically recused themselves.
Pardon me?
I said, I believe they've all physically recused
They have,
themselves.
yes. Mr. Porter, would you like to address the board?
No, sir.
Okay. Any questions from the board? Apologies. Questions to Mr. Gray or Mr. Porter? Do I have a motion?
I'll just say, in case anybody was wondering, Mr. Porter is working on the experience requirements part.
Great.
He's got this under control.
So basically what I'm hearing is that the administrative law judge upheld the screening committee.
Correct.
So I'll make a motion that we go with what the administrative law judge says in the screening committee.
Have a motion to accept the findings of the administrative law judge. Do I have a second?
Second.
Have a second. Do I have discussion? No discussion. All in favor indicate by saying aye. Those opposed, like sign. Mr. Gray, if you will make sure Mr. Porter understands everything we need, and we'll be good to go. Thank you, sir.
Yeah.
Ray, you let screening know that we're back. Thank you. Oh, you do? Yes. Right. Yes, sir. Okay. Yes.
Thanks, sir.
Andy, you'll be up next. You ready?
22 long.
I understand.
He's got his problem.
What?
Yes, one.
Not coming here. All right, next we have our committee report. We'll start out with the grievance committee. Chair, Mr. Burns could not be here. And so Mr. Renfrow will be giving that report on his behalf.
Thank you. Yesterday, the grievance committee met, and spoke about 22 cases. And we'll get started. I do apologize in advance because there's going to be a lot of reading. All right, case 25, PPS 081, Colonel Elder with Sentinel Group. Grievance committee's recommendation that Mr. Elder failed to attend the workshop as directed. Refer this matter to September 2026 grievance committee meeting, further consideration and disposition. PPS 096, Marion Higgs, blindside protection. March 19th, 2026, board finding found a violation of NCGS 74C-11, entered to a consent agreement with Jamarian Higgs of Blindside Protection Agency in the amount of $5,385.60 for 44 unarmed security guard registration violations. The consent agreement may be paid in 3 installments. Staff is to conduct a follow-up registration compliance audit Q4 2026 and Q1 2027. Mr. Pegg is to attend registration procedures training following the March or September 2026 board meeting. July 22nd, 2026 grievance committee recommendation was that Mr. Pegg failed to comply with the terms of the consent agreement. Refer this matter to September 2026 grievance committee meeting for further consideration and disposition. PPS 102, Lars Daniel Remkus Consulting Group. Find a violation of NCGS 74C-2. Continue to cease and desist order previously issued to Mr. Lawrence Daniel and Remkus Consulting Group. Refer this matter to the spring committee should Mr. Daniel or Remkus Consulting Group apply for a license. PPS 106, John Calicut, Walton investigation. We found a violation of NCGS 74C-11, entered into a consent agreement with John Calicut and Walton Investigations in the amount of $2,815.20 for 23 unarmed security guard registration violations. Staff is to conduct a follow-up registration compliance audit of Q2 and Q3 of 2027. PPS 122, Sean Junkman at Axe Airport Services. Final violations of NCGS 74C-11, entered to the consent agreement with Axe Airport Services in the amount of $979.20 for 8 unarmed security guard registration violations. No follow-up registration compliance audit is recommended. PPS 124, Robin Leckie, WTS Security. Final violation of NCGS 74C-11 and NCGS 74C-13. Enter into a consent agreement with Robin Leckie and WTS Security LLC in the amount of $18,237.60 for 73 unarmed security guard registration violation and 1 armed security guard registration violation. Board is to conduct a follow-up registration compliance audit for Q2 and Q3 of 2027. PPS 127, Brian Smith, Piedmont Protection Services. Final violation of NCGS 74C-12A1 and 14B NCAC 16.0707. Indefinitely suspend Brian Smith unarmed guard trainer certification. The certification may be reinstated once Smith completes the 40-hour unarmed guard trainer course. In addition, she must attend 3 unarmed guard training workshops within 1 year and deliver remarks on the importance of complying with the board's laws and rules. This is something new that we're starting to do, and the chair can go in more on that. PPS 132, Colleen Williams, Marksman Security. Final violation of NCGS 74C-11 and NCGS 74C-13. Enter into a consent agreement with Colleen Williams and Marksman Security in the amount of $23,439.60 for 184 unarmed security guard registration violations and 5 armed security guard registration violations. Board staff is conduct a follow-up registration compliance audit of Q2 and Q3 2027. Ms. Williams is to attend registration procedures training following the September 26th board meeting. PPS 003 Gary Mitchell Griffin, fine violation of NCGS 74C-2, continue to cease and desist order previously issued to Gary Griffin. Refer this matter to screen should Mr. Griffin apply for a license. PPS 004 Johnny Calcutt, Boston investigation, file violation of NCGS 74C-12A10, 74C-12A31, 74C-12A29, and 74C-12A25. Revoke all of Mr. Calcutt's license and trainer's certificate. PPS 005 Seth Daniel Walito, enter parish security, final violation of NCGS 74C-13, enter into a consent agreement with Seth Daniel Lito and Enter Parish Security Corporation in the amount of $8,445.60 for 23 armed guard registration violations. Board staff has conducted follow-up registration compliance audit of Q2 and Q3 of 2027. PPS 006 David Grimes, Century Security Services, no violation of NCGS 74C-11. David Grimes failed to attend registration procedure training as part of the consent agreement in case 2024 PPS-00088. Refer this matter to the screening committee should Mr. Grimes apply for a license. PPS 007 Terry Walser with Tri-Metro Security, no violations. PPS 011 John Brown, SAF3 International, final violation of NCGS 74C-2, continue to cease and desist order previously issued to Joshua Brown and SAF3 International. Issue a cease and desist order to Birgit Munns. Refer this matter to screening committee should Mr. Brown or Ms. Munns apply for a license or registration. PPS 012 Michael Toman, Tardigrade Technology, final violation of NCGS 74C-2, continue to cease and desist order previously issued to Michael Toman and Tardigrade Technologies. Refer this matter to screening should Mr. Toman apply for a license. PPS 014 Eugene Beatty, Urgent Security, final violation of NCGS 74C-2, continue to cease and desist order previously issued to Eugene Beatty and Urgent Security LLC. Refer this matter to screening committee should Mr. Beatty apply for a license. PPS 015 Robert Freeman, number 1 fishing hole. That's unique. Final violation of NCGS 74C-13B, continue to cease and desist order previously issued to Robert Freeman and number 1 fishing hole. Refer this matter to screening committee should Mr. Freeman apply for a license. PPS 016 Anna Zoom, Happy Arcade, final violation of NCGS 74C-13B, continue to cease and desist order previously issued to Anna Zoom and Happy Arcade. Refer this matter to screening committee should Ms. Zoom apply for a license. PPS 018 Samuel Harrison, STB Security, final violation of NCGS 74C-10, issue a disciplinary letter of reprimand to Samuel Harrison for a lapse of liability insurance, assess a $1,000 civil penalty against Mr. Harrison. PPS 020 John Anthony Hunt, Affordable Security 365, final violation of NCGS 74C-10E, issue a disciplinary letter of reprimand to John Hunt for lapse in general liability insurance, assess a $1,000 civil penalty against Mr. Hunt. And that concludes everything.
Thank you. Grievance committee also looked at, some revised forms that staff has prepared. They'll be coming back to us again. We want to make sure people understand the enhanced penalty issues, for multiple violations that we're using now. So we're trying to, Mr. Sherwin has, come up with some new forms and, hopefully that will, people understand that what's going on with these consent orders. Before we do anything on the grievance, report, do I have any recusals? Great. That makes it simple. All right, I'll entertain a motion to accept grievance committee report.
Motion.
I have a motion.
Second.
I have a second. Discussion? All in favor indicate by saying aye.
Aye.
Opposed, like signs. All right, screening committee. Done?
Good morning. Our screening committee met yesterday. We had 80 applications for consideration, and we make the following recommendations. Darren Abachi, private investigator approved. William Basinger, private investigator approved. Colby Beatty, private investigator associate approved level 2 with 1,000 hours. Scott Bilski, new branch office, 2 new branch officers, both approved. Scott Bowe, private investigator associate approved level 2 with 1,500 hours. James Bottom, security and patrol approved. George Brooks, private investigator approved with condition of receipt of favorable fingerprints. Kerry Bumbleberg, polygraph examiner approved with condition of successful completion of testing required by Rule .0501. Michael Carlisle, private investigator approved. Kira Cherubin, security guard and patrol approved. Wendy Clark, private investigator approved. Tanya Crum, private investigator approved. Michael Crowley, private investigator approved. Lawrence Daniels, digital forensics examiner, approved with the condition that he and Rimkus Consulting Group enter into and pay a consent agreement of $1,020 for 12 months of unlicensed activity. James Dotson, proprietary approved with additional 30-day QA extension. Christopher Dozier, proprietary approved. Shannon Emmerich, private investigator approved. Brian Guinness, private investigator approved. Kingston Gillespie, private investigator associate approved level 1 with 400 hours. Tomas Plowski, close personal protection approved. Ryan Griffin, private investigator approved. Jane Hall, private investigator associate approved level 1 with 0 hours. Caitlin Hawkins, private investigator associate approved level 1 with 0 hours. Chance Hayes, close personal protection approved. Edward Henry, private investigator denied for falsification of application and unfavorable work history. Ryan Hickey, close personal protection approved. Robert Hubb, private investigator approved. Patrick Huffman, close personal protection approved. Iob Abraham, security guard and patrol approved. David Idle Jr., security guard and patrol approved. Eugene Jarka, close personal protection approved. Madison Jennings, private investigator associate approved level 1 with 800 hours. Jeffrey Cantor Jr., private investigator approved. Corey Klutz, private investigator approved. Benjamin Noss, private investigator approved. Kathy Lale, private investigator associate approved level 1 with 0 hours. Dominic Custo III, close personal protection approved. Jeffrey Mackvick, security guard and patrol approved. Robert Marone, private investigator approved. Douglas Maslar, private investigator approved. Eric McClary, private investigator approved. Charles McMillan, security guard and patrol denied for falsification of the application. Robert Medina, close personal protection approved. Gabriel Miley, close personal protection approved. Edward Pachonto, proprietary approved. Ross Parmenter, close personal protection approved. Cynthia Dawn, pilot Labod, private investigator approved. Cody Ray, private investigator approved. Donald Reynolds Jr., private investigator approved. Tiffany Riley, close personal protection approved. Don Terrier, Roach Cunningham, security guard and patrol approved. Bradley Rowe, private investigator associate approved, level 1 with 400 hours. Joshua Ruiz, security guard and patrol approved. James Russell, close personal protection approved. Justin Sanford, close personal protection approved. Wayne Sankey III, electronic countermeasures approved. Jordan Schroeder, security guard and patrol approved. Donna Sears, private investigator approved. Samuel Seacrease, private investigator approved. Erica Spence, private investigator approved. Zane Statler, private investigator approved. Cedric Stewart Jr., security guard and patrol approved. Jason Sumner, security guard and patrol approved. Ryan Sutton, security guard and patrol approved. John Templeton, close personal protection approved. Aiden Thomas, private investigator associate approved, level 1 with 0 hours. Michael Tuttle, close personal protection denied for lack of verifiable experience. Thomas Walsh, private investigator approved. Marshall Weber, private investigator approved. Michael Weldon, private investigator, approved. Dustin Wilhoit, courier service, approved. Jeffrey Woolard, private investigator, approved. James Wright Jr., security guard and patrol, approved. Moving on to the addendum, Philip Bradshaw, QA for 2 companies, approved. Aaron Patino, QA for 2 companies, approved. Michael Scott, armed registration denial, appeals being withdrawn. Richard Dunning, unarmed registration denial appeal, approved. Jamarian Pegues, close personal protection license renewal and security guard and patrol reinstatement has been deferred. And Alexandra approved, private investigator associate license denial consideration has been approved. And that is the screening report.
Thank you. Do we have any recusals?
Number 68, Michael Tucker.
Any others? All right, at this time, I'll entertain a motion to accept the screening report for all the cases with the exception of number 68.
Motion.
I have a motion. Do I have a second?
Second.
Discussion? All in favor indicate by saying aye.
Aye.
Those opposed, like sign. All right, the case number 68. Do I have a motion to accept?
Motion.
Have a motion. Do I have a second?
Second.
Have a second? All those in favor, or any discussion? All those in favor indicate by saying aye.
Aye.
Those opposed, like sign. Motion passes. Thank you. Next is education and training. The chair was unable to attend today, so I'll take that real quick. We were given a report by Ms. Battle on the training and the courses scheduled. Unarmed guard trainer workshops. We have one in September and one in November this year at Wake Tech. And we also have 5 additional programs scheduled for 2027. So anyone interested in any of these, you can contact Ms. Battle. Firearms trainer recertification, which is the 1 day. We have 3 scheduled, 2 in September, 1 in October. These are at Samarkand Training Academy in Jackson Springs, which is in Moore County. And then we have an additional 6 programs scheduled for 2027. The new firearms trainer course will be held October 20th to 23rd in Salemburg. At this time, there is not a long gun trainer course scheduled. We are waiting to get enough bodies for that. I'm confident that after the October program, there will be some of those that want to sign up and it'll increase. Completed a unarmed guard training class at Wake Tech July 13th. No firearms recertifications are scheduled now because we don't do those in the summer months because of heat and daylight savings time. Ms. Battle was able to go to 2 firearms training programs and observe and found no violations. Everybody did what they were supposed to do. They called the courses correctly. They had all the equipment that was needed and ran the courses correctly. And then finally, weapons discharges. We had 3 weapons discharges that occurred during May and June. All 3 were the same company and all 3 occurred at the various correctional institutions across North Carolina. So we had a discussion about that and looking into it and finding out that the Department of Corrections is supposed to have theoretically has an investigator who looks into this. We would like to get hold of their report and see what they're saying about these violations, because it's obviously a safety concern. Mishandling the weapon, you know, one individual took his weapon out of his holster in a tower to get the serial number for whatever reason and had a negligent discharge. Another one took his weapon out, shot himself in the leg when he did that. And then the third one was checking his weapon, but rather than doing that at clearing barrel, he did it at the tower and discharged the weapon into the grass. So those are obviously concerns that we have regarding training issues in this company. The next thing we dealt with was the course approval. We had 8 new proposals given to us. Computer voice stress analyzer, an analyzer recertification, a tactical emergency care for security professionals, criminal defense investigations, the North Carolina Protective Services Rules, portal navigation and compliance, fire watch and fire safety, comprehensive security guard tactical operations and de-escalation program, and lost assets found, finding, and claiming your unclaimed assets held in state coffers. All 8 were approved. We had a condition that staff review the entire lesson plan and all of the PowerPoint presentation for the NCPPS rules portal navigation to make sure everything is absolutely correct for that. All 8 were accepted with that condition, and then we had 12 classes that were renewals, and those were all accepted by the committee as well. And that pretty much sums up, I think, the training and education report. So I'll entertain a motion to accept training and education report.
So moved.
Second.
I have a motion and a second discussion. All in favor indicate by saying aye.
Aye.
Those opposed, like sign. Law and Rules Committee met this morning, and in Law and Rules, we had 4 rules that have been sent for rulemaking authority. Mr. Gray went over those, where they're standing, and when the public comments period would be on those, which is end of July 31st, and then the second were in August, a couple weeks later. We discussed those. Mr. Gray went over some legislation, which we will not go over at this time. That'll come in his attorney's report a bit later. And then we had several things that came up regarding, Mr. McCray had some concerns about one of our forms and reporting and time elements involved in commission of crimes. And we've asked staff to review both the rules and our policies and bring that back to us. Did I sum that up?
Yes.
Adequately. All right, any questions or comments regarding Law and Rules Committee? Entertain a motion to accept the report. So moved. Have a motion. Do I have a second?
Second.
Motion and a second. Discussion? No discussion. All in favor indicate by saying aye.
Aye.
Those opposed, like sign. Thank you. Finance Committee, Mr. McRae.
We don't have a report at this time.
Okay. No report. We don't have anything to accept, so we don't need a motion. Emerging technology, Mr. Green.
I don't have a report on that.
Same thing. And special committee on licensed activity.
Just to let the board know that I do have a meeting with the district attorney for Pitt County next Thursday.
Okay.
With something that's not relevant to that, but I am gonna bring that up as a topic of conversation. We're very fortunate Greenwood PD is on board with the unlicensed activity, so I urge everyone to seek their district attorney.
That'd be great.
In their county.
Thank you.
Unlicensed activity.
So I have a question. That is a special committee on unlicensed activity.
Correct.
So do we need to make a motion or anything as far as to keep her on that committee?
No, I'll do that.
Oh,
It's done.
excuse me.
Yes. As a chair. And we have
She's done a
two,
great job with that, so I just. was
yeah, we have
wondering.
2 special committees and they are subcommittees of, so,
Okay.
so those are just appointments.
Thank you.
And anything on the 2 boards that staff needs to bring up? I don't have a chair for that, so.
I would just put out a reminder to the guard patrol industry that if you are remotely monitoring or monitoring from off-site the camera feeds of your clients, you need the new limited monitoring license from the Security Systems Licensing Board.
Okay, thank you. That brings us to old business. Any old business? Okay, new business. Oh, you want to talk about A and B?
Sure.
Steve?
First, the annual conference of the International Association and Security and Investigative Regulators, also known as IASER, is October 21st to the 23rd in San Diego. We have several staff members, including Jeff, attending. Mr. Schroll has volunteered to attend, but I did, as usual, want to bring it to the board and see if anyone else would like to go.
It's a great conference.
Yeah.
Okay.
Got it.
Plus, it's my birthday.
Oh, man.
Uh-oh.
Gets me away from the wife.
You can't leave then.
Party
So
indeed.
your wife will be upset if you leave on your birthday.
She'd be upset.
No, she'll be happy.
All right. Do we need to do anything on that? You got it. Okay. Board meeting dates?
Board meeting dates. This schedule, proposed schedule was distributed to you last week. My director's report, it follows the same meeting scheme as this year. I'm always trying to avoid certain holidays or whatever to get us away from those, but otherwise it's the same. So I always bring it to you nice and early for approval so you can get it on your calendar for 2027.
Thank you. And the polygraph testing memorandum of agreement. Sorry.
Would you, if you want that schedule, I think you should probably vote on it.
Okay.
Make a motion.
Agree, second.
All right, I got a motion and a second to accept the meeting dates as proposed. Any discussion? All in favor indicate by saying aye.
Aye.
Those opposed, like sign.
And next is the polygraph testing memorandum of agreement. Mr. Poston led that effort for us, and he is online. Mr. Poston, you should be able to unmute yourself, I think, if you want to lead that discussion.
Okay, can everyone hear me?
Yep.
Okay. For those that you do not know, obtaining a polygraph license is a complex process. The polygraph license is the only license that PPSB issues that requires a written test, a performance test. The applicant appears before an oral panel to answer questions to question formulation, scoring, North Carolina state laws, and other questions pertinent to conducting a polygraph examination. The applicant also has to present 3 sets of charts of polygraph examinations that applicant has conducted. And a chart, I'm sure all of you seen the old pen and ink with the big old long piece of paper. Well, that's one chart. The applicant must submit 3 sets. A set of charts is either 3 charts or 5 charts. So that means the panel has to quality assure between 9 and 15 charts. Somewhere along the line, probably due to the complexity of the issue, Public Protection Services Board gave the actual licensing process to the North Carolina Polygraph Association. Currently, there's nothing in place to delineate who is responsible for what, and there's no guidance from PPSB to the Polygraph Association on how to administer the licensing process. So that means the association can do whatever it wants, whenever it wants, and the board has no control over that. This memorandum of agreement will delineate who is responsible for what, and it gives clear guidance to the North Carolina Polygraph Association on how to conduct the licensing process. And I think you all have copies of the MOA, I think, yes?
Yes, that was distributed.
Okay, anyone have any questions about that?
Have you reviewed this, Jim?
Yes, sir.
That's good.
Sherman and I've been working on it. Yes, sir. We worked on it off and on with the committee.
Okay.
Can I interject something here? And it really doesn't have to do with polygraph, but it kind of does hearing this. So we have these rules for polygraph, but I noticed 2 of the training things coming through for new was CBSA, computer voice stress analysis. Another, not quite as intense as polygraph, but I know that, you're testing somebody. I used to be a CBSA. Is that something that we're just going to let people use that? Or, I mean, if we're putting the emphasis on polygraph, kind of worries me about CBSA just being allowed to be run however, because we just voted for that course.
I would say that we do not regulate CVSA at the moment.
Right. I just don't.
And there's no organization or association that does, there is?
Well, there is an association, there is an organization that does all the CBSA.
We could.
I don't remember where it's out of.
It's just one of those things that's until it's been raised, it's just like the polygraph. The polygraph rules had a slight tweak about 5 years ago.
Yeah.
And then with Mr. Poston being the first, as far as I know, polygraph licensee to serve on this board, right, he took on this project, I guess you'd say, to modernize it. And as he said, to put more guidelines in it.
Yeah.
But I guess the best answer to the question is no one has ever raised the issue or wanted to take on the project of that particular area. We don't have many licensees in that area, but it probably needs the same attention.
Yeah, I figure right now, probably if anybody doing it, I guess you would just have to have a PI license or something. I don't know. But I mean, CVSA is, there's a lot of agencies that use that across the state. And I just know that now with it coming up as one of our courses, I mean, you don't have a problem till you have a problem, but I could foresee that being something that somebody runs without having a certification, and
Right.
I don't know. I mean, it just might be something worth looking at. I'm not saying I want to volunteer to do that, but
focused on,
Yeah.
I mean, there's other things that need attention. That needs attention. The dog handler needs attention. I mean, there's some things that,
is anybody in here CVSA certified?
If they were, they wouldn't raise their hand.
Yeah. Not now.
They don't
But it's-
listen to that either.
the issue with the polygraph, we have there's lots of polygraph examiners, but all your ones with law enforcement agencies and government agencies are exempt. So you have very few private polygraph writers. So we only would get like maybe one application a year, if that many.
Yeah, and it may not be a problem.
Yeah.
And it may be a problem in the future, but when I saw it, us talking about it now, and then I saw it come up as a class, it just kind of,
Mr. Johnson, Mr. Buck may be interested in a subcommittee.
no,
That's
no,
what I'm
not
thinking,
interested.
but
No,
he keeps those running away.
I just thought it was something worth talking about.
Make a great subcommittee. Miss Creech looks eager for another subcommittee.
It would
All
be-
right.
well, you would need rules, but you have the detection of deception examiner in your statute, and that's what we roll polygraph up under. But
It'd be the same thing.
yeah, it says basically any device used to detect deception. So
Yeah.
CVSA, I detect. I mean, I think there's a lot of stuff out
I think
there.
they rejected I detect years ago.
Well, they did, but I mean, as an example.
Right.
I look forward to seeing your work on it. Thank you.
The
All
new
right, based on the information from Mr. Poston's staff and Mr. Gray, do I have a motion to enter into the memorandum of agreement?
So
with
moved.
Polygraph Association. Have a motion. Do I have a second?
Second.
Any discussion? All those in favor indicate by saying aye.
Aye.
Those opposed, like sign. I have one thing, and this applies to the chairs of all the various committees, and I'll notify Judge Burke of this as well. I would ask that the chairs of each of the committees later today either appoint or have your committee select a vice chair so that staff will know who is presenting in the event that the chair can't be there. We ran into that today. I had to fill in kind of all of a sudden, so I'd like to just make sure that we have awareness, so when we know somebody's not going to be there, the vice chair will be prepared to make the presentations and things. So if you would think about doing that, I'd greatly appreciate it. I don't care how you do it, just get us the name. So
I guess the question I have about these committees,
what's that then?
who all is gonna be on the committees? Where is that?
Well, my comment earlier was if you're satisfied with the committees you're on now, I'll leave it alone. If you want to change, then let me know what you're interested in, and then I'll try to match up the numbers to make sure that we have equal representation on the various committees. So. Okay, that brings us to the director's report.
Sir. On the personnel side, we are still fully staffed, and I'm not jinxing myself. We're still fully staffed. We hope to keep it that way.
Cross your fingers.
Yep. Yep.
Don't jinx yourself.
Registration, as you can see here, 17,141 registration applications received calendar year to date. Continue to break records every month, with the number of applications they're receiving. They're doing great work over there. Licensing unit, also very high, 731 license applications, which is the highest we've seen since I started counting in 2019. Applicant background investigations on new license applicants. Our investigators have completed 290 of those. so far this year, also a new high number. And complaint investigations, they've completed 61, which is not the highest compared to the 79 we did in 2024, but we'll probably get there by the end of the year.
Yeah.
And training, 200 trainer-related applications so far this year to date, which when you look at our even numbered years, is much higher. So the staff continues to be very busy and doing a great job. And other information, just for your awareness, in June, I was invited to speak at the Board of Executive Protection Professionals Executive Security Operations Conference in Florida. I was invited to talk about executive protection or close person protection licensing across the United States. I talked a lot about North Carolina, Virginia, and Texas, because those are the only 3 states that explicitly regulate close protection. In many other states, it's either security guards or in some cases, private investigators, they're allowed to do it. The takeaway that I had from that was that industry, not surprisingly, is pretty frustrated by the lack of license portability. They work for clients who tomorrow want to go here, and they may or may not be able to do that, especially armed. And so I offered some guidance about things like interstate compacts, reaching out to the regulators in the states where you go to frequently to see about reciprocity or temporary licenses, that sort of thing. But there were about 350 people there, including some North Carolina companies that were represented. So I thought it went pretty well. I was also, I feel like I'm talking about myself, and it's not about that. It's about letting you know what the staff is doing on your behalf. But I was selected to serve on the ASIS Private Security Officer Selection and Training Standard Technical Committee. The purpose of this committee is to create guidelines that align with the legal and regulatory requirements for hiring and training security guards. I was brought on to be basically to provide the regulator standpoint to this technical committee. Our first meeting is here in a few weeks, so I'll let you know how that goes. And then lastly, to continue the humble brags about staff, Investigator Bill Rafton was selected to serve as a subject matter expert for the Council on Licensure Enforcement and Regulation, also known as CLEAR. They have created a certified regulatory investigator program, and he's been invited to consult on that committee as they develop a new credential for regulatory investigators. He'll go to Denver, I think, in August for that. So our people are doing good things.
Yeah, absolutely.
Moving on to your licensing, registration and certification summary. As I note here, the registration total is wrong. It says there's 11,000 guards in this state. That's wrong.
No.
This was the second month in a row these numbers were low. Thankfully, Promedium has corrected the issue. So since I sent this out and today they fixed it, when I ran the report a few days ago, that number was more like 28,000 security guards in the state. So we'll have that corrected for your September meeting, but I just wanted to report the numbers as they were for this month, but they're low. The license holders and trainer certifications, those numbers are accurate. So about 2,800 license holders and 634 trainers currently certified. Your finances for this fiscal year started July 1, 2025 through the end of May. You've seen your fund balance increase $161,000, bringing its current balance to $2.1 million. That represents about 13 months of average operating expenses in your fund. And your education fund has brought in $13,800, and it currently has $153,000. That's what you use to pay out training and education grants. And the following pages are graphical representations of those financial numbers. I'd be happy to answer any questions you may have.
Any questions of the director? Motion to accept the director's report? Motion second?
Second.
Have a motion to second, discussion? All in favor indicate by saying aye.
Aye.
Those opposed, like sign. Mr. Gray, attorney's report.
Thank you, Chairman. I direct the board members to the attorney's report, which was sent to them electronically last week. If anybody would like a copy, we've got a few that I can always keep that are printed. Starting first with Roman numeral 1 on page 1 is the status of your consent agreements. The first two, 1 and 2, number 1 is the La Sorsa matter that you just heard, and that is an unpaid, of course, the unpaid civil penalty. Number 2, Mr. Pegus, I'm not sure how to pronounce that, Blindside Protection Agency. You heard from both the grievance report and the screening report regarding this matter. It was returned to grievance because it was unpaid. They have given him till September. And also there was a screening meeting matter because they're holding a renewal of one of his licenses until this is paid. So otherwise, everyone is either paid or paying. There's one where being allowed to make payments in installments, but they are either paid or paying. Your hearings list is attached as attachment 1. As always, you've got a few pending matters out there that we are slowly chipping away at. But we've got an interesting thing coming up this month. Look at the very last matter on your hearings list, if you would. For the first time, we've had someone ask for a mediated settlement conference. The Office of Administrative Hearings, something new and different for us. There was a authorization yesterday, a vote in grievance. And since it's a grievance matter, grievance has authorized them. I will ask you at the close of my report today for the full board to authorize Ron Burris, member Ron Burris, to be present at that mediated settlement conference with the authority of the board to settle it. But this is the first for us, but the individual is represented by an attorney and requested a mediated settlement conference, which is something new and different for us. But the other matters have already been dealt with either today as final agency decisions, or we have that one pending matter. We do have a case, Natasha Wms, who is there individually. It is a very curious case. It is Southeastern Protective Agency out of Charlotte. And this has been going on for a while. You'll notice there's a Roman numeral 2 beside it. She maybe in her capacity as qualifying agent, but paid the consent agreement, then refused to sign the consent agreement and petition for a contested case. The Office of Administrative Hearings. Administrative Hearings, after it lingered for a little while, ruled that she had no grounds to petition for a contested case because it was a consent agreement. When the judge denied my motion to dismiss, we just refunded her money. This came back before the board. The grievance committee recommended that that the company's license be suspended for 30 days. She did not come to the second grievance committee hearing. She has petitioned for contested case, and it's very unusual in that she has said on the record multiple times that she is not there as the qualifying agent, and she is not there on behalf of the company, and the company is not there. It's her doing it as an individual. So we're waiting for the final agency decision in that matter, but it's one of the more mind-boggling cases from a legal standpoint that we've had. But that case is pending, and that's why there's no final agency decision date, no nothing. We're just awaiting a proposal for decision from the administrative law judge. But it's very curious. She's there as an individual, which nobody can say whether or not she can do that.
Does she have standing?
She doesn't have standing, so.
Apparently doesn't matter.
But we will be suspending the business license. But she said under both oath and direct questioning multiple times by the judge, you are not here as the QA. No, you are not here. And of course, obviously the company's not there. So it's a very curious situation, very curious. And we're just trying to take it one step at a time. So that's what that matter is. And that's why there's a little blank after it. We're not real sure how that's going to turn out. But unfortunately, the company's is going to be suspended for 30 days. And it's a very unfortunate situation for the company and for how she handled it. Under administrative rules, as Mr. Johnson stated, I reported these to the Law and Rules Committee earlier. At your last board meeting, you voted for amendments to 4 rules. These rules got separated in the filing process because I marked them as 2 of them as pending and 2 of them as approved. Talking with Mr. Sherwin and Mr. Bullard, they said no, all 4 were approved according to their notes. So I filed 2 and then filed 2 a little bit later, which it doesn't really matter because once the public hearings are held, they're going to come back to your November meeting anyhow. So it doesn't really matter what they did get separated in the filing, in the notice, and in the public hearing process. So, but they will come back to you at your November meeting. 0.0707 and 0.0904, the amendments to those 2. Public hearing is Tuesday, July 31st at the board's office. And for the amendments to 0.0705, which is your unarmed guard registration, and 0.1305, your unarmed armored car guard registration, requiring that a transfer of registration now will require a criminal history record check. That public hearing will be on August 25th. Under litigation, I do still reporting to you on the big dog matter. I will probably drop that off. We have not gotten the signed default judgment in that particular case. We're waiting on it. We are having some strange things going on with default judgments right now. Some judges, there is a procedure that they enacted years ago that allows you to default somebody, but in order to default them without a hearing, you have to give them 30 days notice of a hearing. And if they don't respond, then the judge can sign the order. Some judges believe that they can do it that way. Some judges don't. So I'm getting ready to tell you something very bizarre. We are waiting for one, and I don't know why, in Big Dog, which is Jawan Shackelford. We've been waiting for that for some time. It arrived yesterday. We had no hearing. In the next case, number B, which is Mr. Clifton Tinman, Catherine Malinowski, and United Risk and Safety Consulting Group. Mr. Tinman is the one that I've chased all over the planet. 2 sheriff's departments chased him. Finally, we had to get a private process server who was successful on him. For his co-defendants, Ms. Malinowski and United Risk, the judge signed the default judgment without a hearing. On Mr. Tinman, they sent it back to us and said, no, you have to have a hearing. And we used the exact same forms, exact same paperwork, the exact same whatever. So we're just going to schedule it for a hearing, and we're going to have a hearing without him present because he's not going to attend. But it's very unusual. We got different judges in different jurisdictions that believe different things. And in this instance, 2 of them, they did it without a hearing, and 1 of them they refused. And this all comes back from the trial court administrator's office. And I don't know if you're aware of this or not, but everybody here flies, don't you? Everybody here flies. Okay. TSA, trial court administrator's office, and TSA are actually the same agency. I don't know if you know that or not, because whatever you did today, you did it wrong tomorrow. So they're just the same. So you do it this way today and you do it the same way tomorrow, you've done it wrong. So it's shoes off today, shoes on tomorrow. Belt off today, belt on tomorrow. No, belt off today. I thought you said it was belt off. No, it's belt on. So TSA and TCA are actually the same agency. I'm totally and completely convinced, because they don't, trial court administrators' offices do not do the same thing the same way, and definitely don't do it between, say, this county and Wayne County or whatever. It's maddening, absolutely maddening, and we are in the process of that. But that's why this looks so crazy. Third case, Zozarel and Nova 9 Protection. We have tried 3 times to locate these individuals. They were running a company, guards complete with uniforms and everything, in Catawba County. This is a case that Investigator Cheatham investigated. No doubt running a security guard and patrol company. We cannot find these individuals. We've had to do alias inquiries and to chase them, try to chase them down, and we just can't seem to find them. But they were running by all outward appearances, a company that would look legitimate, uniforms and all. We just haven't been able to find them, but I've tried 3 attempts, so I'm just gonna kind of sit and wait till it pops up again. I may have to take a voluntary dismissal and reissue it, but we have not gotten any more complaints on them, but they were at a manufacturing company in Hickory, so trying to find them. Mr. Renfrow made a comment just for David. We want to authorize Mr. Gray to start chasing these people. And that's not to seek an injunction to start the process of chasing these people. And I really appreciated that comment. That's kind of sort of what it's become. We just start the process of chasing them, and we chase them all over the place, such as Mr. Shackelford and some of our fine folks from down in Pitt County that like to operate unlicensed. Under legislation, been tracking a number of bills there. Senate Bill 451 would have required 26 different boards, with the Alarm Systems Licensing Board, now Security Systems Licensing Board, being one of them. This board not being one of them because they listed them one by one, but required them just to arbitrarily cut their continuing education hours in half. Just no method to the madness. There's 64 boards. They all have continuing education, but they picked 26 of those. No question as to why. Been watching it for a while. All of a sudden the other day in a proposed committee substitute, contents were stripped out of that bill, and it became what's called the Universal Licensure Bill. Now, a version of the Universal Licensure Bill was passed last year. And if you go back and flip back through your attorney's reports, you'll see where I reported on that. It passed. It said that we had to recognize a license from another state, but it also said that we would be able to determine the competency of any applicant. And so Mr. Sherwin and I looked at that and thought, okay, well, that means we can say you have to follow our guidelines. Say, for instance, for a security guard or patrol company, you have to have 3,000 hours of experience. And so we made a decision and reported to the board that we did not think you needed any administrative rules or any changes. That bill went into effect October 1. And to my knowledge, nowhere between October 1 and now has anybody attempted to use that out of state. Now they're going back and amending it, although it's less than a year old, to take that language out. And so if this bill passes, that language, it will come out of the bill, or out of the law, out of the brand new law, and we'll probably have to do some administrative rules to deal with it.
So the language they want to take out is that we can
still make them meet our criteria.
So they want to take that out.
Correct. Out of the brand new statute. The interesting thing about that is what it probably came down to is because everybody probably had the same legal opinion that Mr. Sherwin and I did, and that is this doesn't affect us, doesn't accomplish anything, and it really didn't accomplish anything. Because if you say you have to recognize, hey, let me pick somebody we don't have reciprocity with, like we have, reciprocity for PIs. But, if you, Illinois or whatever, and then you say they still have to meet our criteria, well, what good does that do? And obviously somebody pointed that out to them along the way because they're yanking it out. Because it really, the law really didn't do anything. And this whole universal licensure business is a national trend going on in legislatures. It's not political, it's not Republican or Democrat, it's not political party, it's libertarian. It's a very libertarian thing to have portability of licenses from one state to another. And it's not just us, it's all licensed occupations and professions. So it's everybody. But they yank it out, it's going to make a change. Last year's bill was called the Neighbor State License Recognition Act. And it listed our neighbor states, which everybody laughed at because all of a sudden West Virginia is one of our neighbors. But that will come out also, and it will be all 50 states. So instead of just the contiguous states around North Carolina and West Virginia, it will now be all 50 states, all territories, and the District of Columbia. But we're watching it, and I say we because myself and the attorneys that do what I do, as well as Paul's equivalents among all these other boards, are watching it pretty closely because it is going to happen. This time around, it'll upset the apple cart, and we'll have to look at it. Next one, some other bills that we've been watching along the way have been gutted and used for other things. I explained in there what a committee substitute is, and that is what happened to this particular bill. And then it became the Universal Licensure Act. They gutted the other bill, and they can go in, if it's passed either the House or the Senate, they'll take that bill, gut it, and it only has to go back to that chamber. And so they've been doing that quite often, or they do that quite often at the end of a session. Oftentimes to get bills that are voted on in caucus to get them out and moving. And it's called a committee substitute. But we had House Bill 949, School Protection Act. You've had House Bill 280, Private School Security Act. That's the one that would allow employees or volunteers of a private school. Wouldn't include contract security guard and patrol, but employees or volunteers of a private school to carry a firearm on the premises of the firearm or a stun gun on the premises of educational property. That got gutted. It's no longer there. It's the Dominique Moody Act now, and it has to do with child welfare in the Department of Health and Human Services, WISCOM. Then the somewhat infamous Freedom to Carry and NC Act, which is Senate Bill 50. That's the one that would allow anybody over the age of 18 to carry a concealed handgun without a concealed handgun permit. Has some other details in there, but that bill was approved by the Senate, and it's been on the House calendar now 13 times for a vote, and it's not been heard, and I don't think it will be. Last was on the calendar in April, but I think that handwriting's on the wall that it's not going to pass. We have, just to make you aware, most of you all aware that they are now using private security guard and patrol companies on contract at the prison units around North Carolina. Department of Correction is. They have been doing that for a few years now with about a 2-year sunset on it. Every 2 years it'll sunset. It was in Senate Bill 355, which is entitled Support Department of Adult Correction. It was in there. For some strange reason, on June 9th, there was a committee substitute for that bill, and it yanked it out. Everything else stayed in the bill, but they yanked that sunset out. And unless it appears somewhere else, that will sunset. So I don't know if there's an intention of not using correctional officers in the prison. Private contract security in the prisons, and they are not literally in the prisons. They are manning the perimeter in towers. They are not serving as correctional officers. They are just in the perimeter in the towers. I don't know if they're going to undo that or not, but it did get yanked out. And then finally, after many, many years, almost 10 years, there was a U.S. Supreme Court opinion called Federal Trade Commission versus North Carolina Dental Board. It did originate out of North Carolina, but affected all occupational and professional licensing boards across North Carolina. There was a bill introduced back then, back in 2017, to make adjustments to bring boards into alignment with that Supreme Court case. I go to a lot of conferences. I'm going to one, leaving tonight for its next 2 days. It's been a topic of discussion. Every state in the nation has done something to adjust their occupational licensing boards to be in alignment with that U.S. Supreme Court case, except North Carolina, the case from whence it originated, which I find rather ironic. But every other state in the nation has addressed that Supreme Court case. There was a bill in 2017. It got yanked. Interestingly enough, by committee substitute, it was used to repeal the infamous bathroom bill, House Bill 2, if you remember, about using the bathroom of the gender on the birth certificate. That was so controversial. For some reason or another, they used that bill and we lost it. But the good news is I was part of the group that drafted that bill in 2017. And when we did your new bill, your Modernization Act, passed last year, I made all the changes necessary in that bill, so you're covered. if this bill passes, we're in good shape. We've already got the changes made that it orders other boards to do, so that'll be good. So that's it.
All right.
I know
Any
that's
questions?
rather long, but we got a lot going on.
Any questions for Mr. Gray?
Yes, you mentioned the sunset on this, private security doing the prisons. I'm trying to understand, did that have anything to do with always shootings and always accidental discharges we've had at the prisons?
No, I wouldn't, I mean, I don't think it has anything to do with it at all. I think the difference is, Mr. Baz,
There was a time limit initially in using
yeah.
private security in prisons, and it would go back to the Department of Corrections.
Go back to the Department of Corrections. I think what you're seeing, Mr. Epley, and Mr. Buff made a really interesting observation. For those that don't know, if you were listening a few minutes ago and caught what was being said on the report from Training and Education, we're having a lot of unintentional discharges at these correctional facilities by the contract company. And it caused concern and a lot of discussion in the committee meeting is what Mr. Epley is referring to. And it seems to be an inordinate number. But Mr. Buff made a really interesting observation. He said it may be worse in law enforcement and it may be worse in the Department of Correction before they had contract folks. And we wouldn't know that because those aren't reported. Law enforcement agencies don't have to report theirs to the Criminal Justice Standards or Sheriff Standards Commission. Of course, the Department of Correction, they have people that investigate it before you had this problem. But it was a real interesting observation that Mr. Buff made, and I think he's probably correct. It may be better than what the Department of Correction is. We just don't know. We just don't know. You know?
I would say across the state in law enforcement, there's probably an accidental discharge nearly every day. or at least a couple times a week. Negligent discharge.
I call it unintentional.
Yeah, but I mean, it's not reported. You don't have to report it to CJ standards. So who knows if they are or they're not? We don't know.
I'm sure some of the DOC has it, but I bet you know, they keep it buried. But you know, it could be better. It actually.
Moving on.
Yeah, there you go.
I need a motion to allow Ron Burris to represent the board at the Administrative Settlement Conference on the.
Motion.
Second.
I have a motion to second. Discussion. All in favor indicate by saying aye.
Aye.
Those opposed, like sign. All right, I'll need a motion to accept the attorney's report.
So moved.
Motion, second,
Second.
and a second. Discussion. All those in favor indicate by saying aye.
Aye.
Those opposed, like sign. Any comments? Good of the order. Do we have anyone wishing to make a public comment? Anyone signed up? All right. Any industry associations update? Yes, sir.
Thank you very much, I'll get it out, Bill, I'm getting it. Administrative Vice President, Secretary of the NCPPSB, North Carolina Association of Private Investigators. Just a few things, and I'll keep it real quick. The meetings have gone real quick today, so I don't want to be a hindrance. As of right now, we have 272 members. It is growing. Of course, we do see more members joining as our conference comes near. We just finished the conference up in April. We had less there this time, and we are really looking at that because of the fact we just had one in November and 5 months later had another one. Our next conference will be at Harrow's in Cherokee. So save your money up, attend it, and we'll of course have some classes there as well. That will be April 19th to 27th. Other than that, the only other thing I have is our scholarship program that we award children of private investigators, and therefore there's some things that written into that will be awarded. We'll announce it at the next meeting, of course, coming up in August. And that's all we've got. Thank you.
Is one of your classes and Harry's going to be on blackjack or?
See me afterwards.
Thank you. Appreciate that.
Yeah.
All right. At this time, the board is going to go into a closed session. So we'll need to ask people to step out. So we will not adjourn until after the closed session.
Need a vote.
Pardon me?
I move that we move into closed session.
Second.
Motion to second to move into closed session. All in favor indicate by saying aye.
Aye.
Those opposed, like sign. Thank you, folks, for coming today. Appreciate it.
Folks are staying in now, what is it?
They can stay in. They'll stay on.